Hello, how are you? I hope you all are fine. Let's today discuss the topic of speedy trial in Indian criminal justice system. And the important and landmark case regarding this is Husainara Khatoon versus Home Secretary Bihar 1979. In this case, a public interest litigation, that is PIL, was filed by advocate Kapila Hingorani in Supreme Court, whereby she told the court that in jails of Bihar state, especially Patna jail and Muzaffarpur jail, there were many under trials who are languishing there without trial being conducted, and police haven't filed a charge sheet up till now, and they have already spent a lot of time in the jails. Some of the under trials have spent more than they could have actually been convicted by the courts. You see, if had been there they've been convicted by the trial court, they have already spent more time in jail as a under trial. So their case was put up before the court, Supreme Court, by Mrs. Hingorani, and the Supreme Court gave a very laudable judgment in this case. You see, procedurally, there was no case in which a lawyer can directly go to the Supreme Court and bring a newspaper cutting and ask the court to take cognizance of the case, because there was no precedent. But this was the first case in which public interest litigation was introduced. So Justice P.N. Bhagwati was in the two-judge bench, and he gave the judgment. And Justice P.N. Bhagwati, as you already know, he is known as the father of the public interest litigation, and Mrs. Hingorani, who filed this case as a lawyer, she is known as the mother of the public interest litigation, because she was the one who filed this case. So though she didn't had any locus standi, because at that point of time lawyers had to file a power of attorney in the courts, in the Supreme Court. But she can't file power of attorney because there were many inmates, jailmates in Muzaffarpur jail and Patna jail, and it was not practical to get power of attorney or their signature on the wakalatnama or power of attorney. And that's why, as a public spirited person, she filed this case in the Supreme Court and asked the court to take cognizance of this case, because it's of a public nature. So court considered that at a public interest litigation, in Hindi we call it Janhit Yachika, and court took cognizance of the case, and court directed the state of Bihar to give the court different categories of prisoners who are lodged in the various jails like Muzaffarpur jail and Patna jail. And basically there were four categories of inmates, under trial prisoners. First category was those of the prisoners who were involved in a bailable offense, but because they are having no money, they were poor, they were from the poor strata of the society, they could not furnish bail, they could not arrange money for getting bail bond, they could not arrange sureties for their bail bond, they could not even file a personal bond because they had no money, or they didn't had any knowledge about this thing. So no legal knowledge, they were poor. So this was the first category, those who were involved in bailable offense. Then there were three other categories. For example, the second category was those persons who were involved in non-bailable offenses, and they have already spent more than half of the punishment in the jail. And the third category was those persons who were involved in non-bailable cases, but they haven't completed half of the punishment in the jail. And the fourth category was those who were involved in non-bailable cases, but they have not completed the half term actually, which can be given to them if they were convicted. So already they were under trial prisoners, but they haven't completed the half of the actual punishment which might or could have been given to them in case they were convicted by the court. But there was no question of conviction here. The trial was not being conducted, the trial was pending, and they were under trial prisoners. police haven't in some of the cases filed the charge sheet also. Charge sheet is known as police challan. So after investigation of the case, after arrest of the accused, during the investigation, the accused can be granted bail by the court in case of bailable or even non-bailable offences, or he could be lodged in jail. That is known as judicial custody. But the police investigation could take time. The police police can take time during investigation, and there can be lot of time spent by the police investigating the case and not filing the challan. And same happened in these cases. The police haven't filed the challan, or in some cases the police have filed the challan or police report. The court took the cognizance of the case, but then in the court itself, that case was pending. It was not concluding because of certain factors in Indian courts, So justice delayed is justice denied. You all know about this. So court took cognizance of these cases. Supreme Court took cognizance of this matter of Mrs. Hingorani PIL, and direction was issued by state of Bihar to give the court all the lists of cases, all the lists of persons who were lodged in various jails of Bihar, and categorize them according to the offense they have done. They are involved. For example, major offences, minor offences. So categorize them and give us the list of all these persons who were involved in this case. So at the end of the day, the court gave brilliant judgment, in which Justice B.N. Bhagwati also gave emphasis on Article 21 of the Constitution of India, which says right to life and personal liberty, which involves right to dignified life, and right to speedy trial is also included in Article 21, that is right to life and personal liberty. So these inmates, their right to life was involved, and they are denied of this right to life, and there should be a procedure established by law. This procedure was very lackadaisical, and they were not given speedy trial by the trial courts. So various directions were issued by Supreme Court in this case, Husainara Khatoon versus State of Bihar, and at the end of the day, quite a lot of prisoners were released by the court. Then Mrs. Hingorani filed another PIL in the same name, Husainara Khatoon. And by the way, Husainara Khatoon was also one of the inmates of the Bihar jails. So then Mrs. Hingorani told to the court, Supreme Court, that there were many other states, also 7-8 states in India, in which in various jails same thing is happening in various states, and the under trial prisoners they are also lodged in various other states, so please take care of them also. But the court said her to file another case in the same name, so she filed 2 more cases and with the same name, Husainara Khatoon versus different states, and there were actually 3 cases, Husainara Khatoon. So in next 2 cases, various inmates of these different jails of different states, they were released. Basically the under trial prisoners were released, and the total of 40,000 under trial prisoners were released from various state jails in India. So that was a landmark decision, and it affected the future decisions of the Supreme Court, and up till now this decision is held as a landmark decision. And Justice Bhagwati, because he was the main judge in this case, and he was known as the father of the public interest litigation. This can come in your preliminary exam of judiciary. So all those who are preparing for judiciary exams, they can contact me. My contact number is 9646526942. 9646526942. You can WhatsApp me, and you can get the details of the course. Basically, you can prepare for Punjab Judiciary, Delhi Judiciary, and Haryana Judiciary through online or offline courses. What will be the fee structure? There will be minimum fee structure. You can talk to me on phone or WhatsApp me. I can give you all the details of the courses. So thank you very much. I hope you like the lecture.